Introduction to Law. Sources of law. Sources. The common sources of law are codified laws, judicial precedents, customs, juristic writings, expert opinions, morality and equity. With the growing popularity of the idea of constitutionalism, legislations and precedents occupy the center position amongst all the various sources of law. The meaning of the term, sources of law, differs from writer to writer. The positivists use the term to denote the sovereign or the state who makes and enforces the laws. The historical school uses the term to refer to the origins of law. Others use it to indicate the causes or subject matter of law. Professor Fuller, in his Anatomy of the Law, states that a judge interprets and applies certain rules to decide upon a case. Such rules are obtained from various places which are known as sources. He further goes on to give examples of the common sources of law such as codified laws, judicial precedents, customs, juristic writings, expert opinions, morality, and equity. Holland has defined the term to mean the sources of the knowledge regarding law. Classification. There exists no definite classification of the sources of law. Different thinkers and jurists have given their own classifications, according to their own understanding of the meaning of the term. Salmond's classification. According to Salmond, there are two main sources of law: formal and material. Formal sources are those from which law derives its validity and force, that is, the will of the state which is expressed through statutes and judicial decisions. He subdivided the material sources into legal sources and historical sources. Legal sources comprise of legislations, precedent, custom, agreement and professional opinion. They are authoritative in nature and origin and are followed by the courts as a matter of right. On the other hand, historical sources are those which are originally found in an unauthoritative form and are subsequently admitted and converted into legal principles. For instance, precedents are a material source of law. However, domestic precedents are legal source, whereas foreign precedents are historical source. Salmond's classification of the sources into formal and material sources is found to be unsatisfactory by critics. The editor for the 12th edition of Salmond's Jurisprudence has classified the sources directly into legal and historical. Keaton's classification of the sources of law has emerged as a critique of Salmond's classification. He defines the term as those materials from which law is eventually fashioned through judicial activity. He classified the sources of law into binding sources and persuasive sources. Binding sources are those which have to be necessarily followed by the courts. Legislations, judicial precedents and customs are examples of such source. Persuasive sources are those which come into play when there is absence of any binding source on any particular subject. Foreign precedents, professional opinions and principles of morality or equity are examples of persuasive sources of law. Common sources of law. The common sources of law are as follows. Legislation. The term legislation has been derived from the Latin terms legis meaning law and latum meaning to make. Thus, legislation refers to the making of a law. Salmond defines legislation as, legislation is that source of law which consists in the declaration of legal rules by a competent authority. According to Gray, legislation refers to the formal utterances of the legislative organs of the society. The analytical school of jurisprudence believes the law to be a set of commands issued by a sovereign authority. This command is what is known as a statute, and the process of making of a statute is known as legislation. The analytical positivists believe legislation to be the only true source of law and disapprove of judiciary taking up legislative functions. Furthermore, they do not recognize customs as a valid source of law. On the other hand, the historical school believes legislation to be the least creative source of law. They believe that legislation only gives a proper form and structure to the customs that have been developed by the people. Both the views are the two opposite extremes of regarding legislation as a source of law. While the analytical school regards legislation as the only source of law, the historical school disregards it as a source of the new law. Salmond's classification legislation. Salmond has classified legislation into supreme and subordinate legislation. Supreme legislation. Supreme legislation refers to the laws made through the exercise of the sovereign power of the state. The power to repeal or amend such laws rests only with the legislative body, which has enacted the laws. Subordinate legislation. Subordinate legislation refers to the laws made by an authority other than the sovereign power of the state. Such laws are in constant supervision of the body, which enacts supreme legislations. One of the kinds of subordinate legislation is delegated legislation, which is quite popular in the contemporary world. Don't forget to subscribe, like, and share. See you in the next video.